technology law firm. We have over 350 technology clients, ranging from clients in the space sector, pharmaceutical, startups, one of the biggest restaurant booking platforms in the world, all sorts of different interesting, exciting technologies, working in this with autonomous vehicles as well. Maybe have to speak to you about that later. So we've heard from lots of people about working with not just their own organisation, but working with other organisations. We had Horizon 2020 mentioned. We're in a university, and the university works with other organisations, companies, and this is the sort of contract you need to run a project when you have different types of organisations and parties. So here's a group of disparate people that might want to get together and do a project together, and they all have different interests and ideas and personalities. And so how do you get a multi-party situation like this into a framework or a contract which is manageable and meaningful and covers all the bases? You've also got funders probably involved, and they have their own interests. So let's imagine we've got a university, we've got a software company, we've maybe got a government, and we have perhaps the end user, the person that this project, this bit of software or this product's being built for. This isn't a framework agreement, this is a collaboration agreement. You could set up a company and have a single purpose vehicle company, but you're not going to get a government and a university and a high street name and a software company all to agree in the terms of entering into a single purpose vehicle very readily, and it has all sorts of governance problems, taxation problems, and other things like that. So they want to have their own identities, they want to work together, but not be actually in business together. So they're all bringing different things to the table for the purpose of this project. They're not in a partnership. That's a very dirty word. Partnership's a disaster to be in. It's a very bad model, a very bad vehicle. Law firms tend to do that, God knows why. I'm not in a partnership, I actually set up a company. Because if one of your partners buys a yacht or does something crazy, all the other partners' houses and record collections and things like that are on the line. Showing my age there. Before you get into your drafting of a collaboration agreement, you actually need to be able to tell each other about your secret sauce, what you've got, why you should be a partner, why you should, well, not a partner, but why you should be a collaborator, why you should be coming to the table to be involved in this. And you need to enter into a non-disclosure agreement, either a multi-party non-disclosure agreement or a series of non-disclosure agreements. But don't try drafting them yourself. I've got lots of clients who try drafting non-disclosure agreements. I hate drafting non-disclosure agreements. We must draft about between 6 and 10 a day. We spend all the time looking up obscure company registers in Azerbaijan and China and things like that, because if you get the company name wrong, the company number wrong, you've got a non-disclosure agreement with nobody, with a company that doesn't exist, and it's not worth the paper it's written on. And people think, oh, it's just a non-disclosure agreement, but you're telling everybody about your secret sauce. So you need to have that protective bubble of the non-disclosure agreement. And the non-disclosure agreement is not a substitute for a proper contract. It's a pre-contract contract, which allows you to talk about the contract you're wanting to enter into. And I'm going to talk about the front end and the back end of the contract. The front end is the boring legal bit that I do. The back end is the exciting bit of the technology and all the stuff that you're going to be dealing with. And I have to understand as a technology lawyer what the underlying technology is going to be. Otherwise, I can't draft the front end to make any sense. These are all the questions that you answer in any contract. Most contracts, not just a collaboration agreement, these are the questions you have to answer. So who are the parties? And we talked about getting the parties' names right, something basic like that. Company numbers, why are you entering into the collaboration? What's it about? Where is it being performed? Is it being performed in different countries? Clients who are observing the rainforest canopy in Guatemala for the Guatemalan government. They're partnering with the Guatemalan government, their space technology company. They also have two satellite companies, two global satellite companies. But it's a Guatemalan project, but we don't want the Guatemalan legal system to apply to this because it's a bit of a lottery. So we use English law. It's painful to say that as a Scottish lawyer, but we use English law a lot of the time. We're also qualified in English law because it's a universal common denominator legal system. When is it being performed? What is the program, the timescale for this? How is it being performed? What's the methodology? And what is being built? What's the specification? And if we can answer all of these questions and capture them in a contract, we'll have a half-decent contract. So as I say, the boring bit is the legal bit that I do, the front end. There's a lot of standard clauses, but you also have to understand what's going to go in the back end of the contract. before you can draft the front end of the contract, because the technology informs what you're going to be talking about in the front end. So you have a definition section either at the beginning of the contract or the end of the contract, and that's where a lot of the bespoke and special terms that you're going to do, because you'll have clients talking about raw data, they'll be talking about, they could be talking about electronic point of sales, they could be talking about machine learning, they could be talking about all sorts of specialized terms, and you've got to capture them, understand them, and then say what they mean in understandable language that your clients will agree is correct, and that a reasonable, sensible person reading this contract would understand. A good contract can be read by any intelligent person, and they should understand what it's about. A bad contract is abstruse and difficult to understand, and if only a lawyer can understand it, then it's a bad contract. It should tell a story. So you might have a definition of affiliates. That might mean that if a company is involved, it's intellectual property belonging to the parent company or the holding company, subsidiaries. They're also involved. We're going to talk about intellectual property rights, which are very important. When you come to enter into collaboration, you're coming to the collaboration because you've got something to offer. You've got some secret sauce. You've got some background intellectual property that's going to be used. That's what you're bringing to the table. That intellectual property is going to be mixed with other people's intellectual property, and you're going to have a product. And that end product may contain new intellectual property or resultant intellectual property. You want to have a starting position as to who owns what, and then who is going to exploit the product at the end of it. And there's a stupid analogy I use of a sausage machine, which the German lawyers and the European Space Agency seem to like very much. The worst analogy, they said, which is one party will own the breadcrumbs, one party will own the sausage meat, one party will own the herbs. They're all put into a big data refinery or a process, mashed together, and a sausage comes out at the end. Who owns the sausage? It's made up of all the ingredients of different people. And we've got to, in this collaboration agreement, say, you provided that raw data from the satellites, you provided that software for mashing up the data, you did this and you did this, you already owned that. We all put it together in a big machine, and we have a nice user interface, and we have a nice early warning system for the Guatemalan police force to see that people are chopping down trees in real time, and we can go to the forest and catch them. So you have to license your intellectual property into this thing, because other people are going to use it, but you might want to use it elsewhere for other projects. So we have to look at that very carefully. In a collaboration, you have to have a lead partner. You have to have a lead party, because you can't all be equal. Somebody has to take the lead. Somebody has to usually be the lead partner and deal with the financiers. They have a head project manager, and you'll have a steering committee, because all of this is governance. You're not in one company. You're disparate companies working together, so you've got to have a way of actually working together and process if things go wrong or you hit a stumbling block. You've got to be able to have governance meet at your steering committee and then actually navigate your way through any problems. So you have a project manager, you have a project plan, which is your program, you have a project spend, which is your financial element, and we have a steering committee. And what is interesting or unusual about a collaboration agreement is you're usually working on a product that doesn't exist. You're working on a future product that is a solution to a problem. So if you use the rainforest situation, the Guatemalan government says our biosphere is being ruined by people chopping down trees, and it's affecting all the animals and things like that. How do we deal with this? So my client said, well, we can use these satellites. The best ones are optical satellites, but it's very cloudy a lot of the time in the rainforest, so we need radar satellites as well to see through the clouds. So we need a company that owns radar satellites, and we need a company that owns optical satellites. And then we need software developers to get all the satellite data, huge files, mash them together, put them through some programs that have some machine learning in it, and then spit out all the information into into a user interface for the police force. So nobody's invented this, so it's a rather agile procedure you're going through. You have an indicative program saying it's going to take a year. We've got a year's funding from the Guatemalan government and from the European Space Agency and from money from NASA as well. And we've got the spend, but we don't really know how much it's going to cost. So you've got to have a process of working out big milestones to start off with, and then narrowing them down. It's like writing a book. You start off with the title of the book, and then you write chapter headings, and then once you've got the chapter headings and you're getting into it, you can finesse that and work out into different paragraphs, and you get granular in the detail, but it's an agile process of development. So to continue the uninteresting front-end situation, you've got to work out the responsibilities and liabilities of the parties. What if you realize, actually, we need some drone guys to come in and take pictures, or we need other types of coders and other companies with other abilities that we don't have. You have to have an ability to bring in new parties and onboard new parties and deal with their intellectual property and their share of the money or exploitation of the product or whatever. So you have to have an ability to bring on new parties. Change control procedures. Any contracts you do should have a change control mechanism in it. Most of the contracts I see drafted by the people seem to forget this. So it means that if there is a change to the program or a change to the specification, which is going to affect the budget, is going to affect the price, then you have to be able to navigate around that, and you have to have a mechanism for it. And it can't just be an agreement to agree. It's got to be a measurable mechanism of working out what impact on price and program that's going to have. What if somebody wants to leave the project? If they leave the project and take their ball with them, the game might stop. So you have to make sure that they've licensed their intellectual property, background intellectual property, into the game so that you can continue to play, and you might have to pay them royalties to use their intellectual property. So we deal with IPR ownership, and the use of intellectual property is very important, because once you've built this, as we say, who's going to get to exploit this? Well, my client in the Guatemalan situation is going to license the product to the Guatemalan government. The satellite companies will get royalties for the satellite data they put in. There's a university involved in it as well, and they'll get to use the information for academic and research purposes. So everybody gets their slice of the pie, and it all has to be pre-legislated in the collaboration agreement. You can't have a bun fight or a pie fight at the end of the whole thing, because this all has to be legislated for at the beginning of the contract. Extensions of time, dispute resolution. We are coming out of the European Union. We will still have ability to enforce decrees in each other's countries, probably. But if you're dealing with Russia or China or anywhere else, you don't want to have, or the Middle East, you don't want to have to try and enforce a United Kingdom court decree in China. It's a waste of time. But there's a thing called the New York Convention, signed up in the 1950s, about arbitration. Everybody will recognize each other's arbitration decisions, so you go for arbitration. Language and time zone, you want it to be in English if you're working in English. Time zone is important, because if you've got deadlines, and say 25th of December is your deadline, you must have this done by. Well, 25th of December arrives in Australia 12 hours before it does here, so you need to work out what time zone you're working on. So if you go to the more interesting part of the contract, the back end, this is the interesting part, because the boring legal part is, largely similar. This is the stuff that we need to know about as lawyers. We need to understand what the hell's going on, what you're trying to build, and so we have to have a specification. This is the what question. And you can have a static specification like that, a blueprint. That's the technical specification, but how is this thing going to function? You need a functional specification. What warp speed is this going to go at? What photon torpedoes is it going to have? All of that other stuff. It's got to perform in a certain way. We've got to see the trees being cut down. You can't just have a picture that's old. It's got to be in real time. So you've got to work out the specification, not only just the functional, the technical specification, what lamp stack you're using, software, whatever, but how it's going to, the outputs of it. And how are you going to do that? The methodology is the how part. It's linked to the specification, which is the what part, and the when part is the program. So all of these things are interlinked, and you've got to answer all these questions. And the specification will grow, because, as I said, it's a future product you're creating. So you have to have a way of developing that specification. And the trouble is, you probably have a fixed budget. And we all know about agile development software. If you're trying to develop an agile process and you start putting bells and whistles on it, it costs more, and you push out your program. So you've got to be very careful that you have as much specification as you can to start off with, and then you have a methodology for developing out the specification that is measurable. And we have our schedules of background intellectual property at the back of the contract as well. Intellectual property, this is the International Space Station. I've got clients who have been asked by NASA to put sensors on the International Space Station. NASA has no route to market. My clients can choose 3 sensors and then revenue share with NASA. So that's a collaboration. The time zone is Greenwich Mean Time on the International Space Station. But depending on what part of the International Space Station you're on, the intellectual property, the law applying to that intellectual property will be the nationality of the part of the space station you're on. And what we don't want to do is bring on the sensors via a Dream Chaser onto the American part of the space station, because the ITAR rules for military specification, everything to do with space in America is a military specification. So you'd have to have an ITAR license from the Department of State, which would take about 2 years to get. So we have to sneak on via the European part of it, or the Japanese part of it. So the other things that you're going to have in a big model like this we've talked about today is data and data processing, data refineries. Who owns the data? The data might then be changed and tagged and assimilated and put into a database. Who owns the database? Who owns the processed or refined data? All of that has to be dealt with. Then we have the joys of personal data and the general... Okay, the data protection regulations. So there we go. Licenses, I haven't got time to tell you about licenses, but we touched on it briefly about how you actually license things to one another amongst yourselves and license to the end user. Payments linked to program and currency, and that's it. Okay, Crystal, start.